Hey, thanks for making it to Veterans Info Tap. This is important. I'm glad you made it. Stick with me. The VA is on the ropes. On the ropes because we have two veterans that are pushing the issue at the Supreme Court. This is really important with regard to your benefits for disability compensation and how the VA views them to be service connected or not. This is a big, big deal. Please hit the thumbs up, subscribe, share with a friend, all that good stuff. I really appreciate it. The two asks are really, look, please hit the thumbs up, let the video run. Those two things will help push this information out to others and really shine a light on this big problem within the VA. Now, with that, if you want to support the video and the channel in other ways, consider being a member. You can go to the homepage. You'll see the highlighted members and a join button. Thank you so much to all you members. I truly, truly appreciate your support. Now, before we jump into it, I want to throw on a special thank you to David Lambert, 1596. David Lambert, 1596. Thank you so much for the super thanks in the comments. I really, really appreciate that support. Thank you so very much, David. I appreciate you. All right, so let's jump back into this. We have here the headline is, two veterans will argue to Supreme Court that VA disability claims aren't getting benefit of the doubt. For those that don't know what that is really meaning, the way that the process is supposed to work is that if evidence is coming into the VA, and if the evidence is in equipoise, meaning that it's equal on both sides, for you and against you with regard to service connection, the VA is supposed to rule in your favor. What they're saying is that when evidence is equal, the VA isn't always ruling in your favor. And I'm sure there's some of you out there that can agree that you feel the same way. So let's jump into this article, turn over some stones. I'm probably going to do another video on this too, just to get the word out. So the Supreme Court will hear oral arguments Wednesday in a case that challenges the Department of Veterans Affairs handling of handling of benefits, applications, and appeals, a question that could affect thousands of previously decided or current claims. In the case Bufkin versus McDonough, the plaintiffs challenged decisions by the VA and the Court of Appeals for veterans' claims. Now, again, just to kind of give you the process, right? You file a claim, it's denied. You could put in for a higher level review, denied. You could put in for a supplemental claim with additional evidence, denied. You could push it to the Board of Veterans Appeals, the BVA, and let's say they deny. Now you can push it to the U.S. Court of Appeals for Veterans Claims, and let's say they deny. Then you could potentially get it heard at the Supreme Court. So that's where we're at. So they are challenging those decisions all the way through the U.S. Court of Appeals for Veterans Claims, denying benefits for health conditions. They argue that the Veterans Board of Appeals, the VBA, and later the appeals court failed to apply a benefit of the doubt rule that should have resulted in disability compensation awards. By law, veterans are entitled to receive the benefit of doubt when the presented evidence is either for or against approval is close. The Veterans Appeals Court, established in 1988, weighs decisions by the Veterans Board of Appeals and is supposed to ensure that the board followed all regulations when making decisions, including giving the benefit of the doubt to the claimant, according to the Veterans Benefits Improvement Act of 2002. Moving on. But veterans Joshua Bufkin, who served in the Air Force from 2005 to 2006, and Norman Thornton, a former Army soldier who served from 1988 to 1991, says the board and the courts, including the Federal Circuit Court of Appeals, did not follow the law when upholding the board's decision. Both plaintiffs applied for benefits but were denied repeatedly by adjudicators and on appeal, with the VA deciding they were ineligible in Bufkin's case or did not qualify for rating increases in Thornton's request. Moving on, according to court documents, Bufkin served in the Air Force for 6 months during a time when his wife experienced mental health issues, and he was under tremendous strain to balance family and work life. He was awarded a hardship discharge after consulting an Air Force psychiatrist and later applied for VA health care and benefits with VA doctors in disagreement over whether Bufkin had post-traumatic stress disorder, and if so, whether it was service-connected. Adjudicators, the board, and the court all rejected his disability compensation claim for PTSD. Now, here's the thing. Look, I have no clue about this person's situation other than what I'm reading, but the bottom line is that there are tens, hundreds, millions of different scenarios out there where the VA potentially did not give the benefit of the doubt to the veteran, and the circumstances could be different. So whether or not we, from a very far outside view, agree or disagree, because it's easy to get wrapped around the axle, right? With some of this stuff, we have no evidence. We have nothing to look at. We don't know the story. We're getting a very high level overview of kind of the process that took them to where they are. And obviously, in my opinion, there is enough backing them to where, one, an attorney firm took them on, and two, the Supreme Court allowed this to be actually heard, because the Supreme Court can reject this stuff all the time. So, moving on. Thornton was a soldier who deployed to Saudi Arabia and Kuwait during the Persian Gulf War, serving on a tank crew and performing combat life-saving duties. He applied for disability benefits in 2005 and received a 10% disability rating for PTSD. That later was upgraded to 50%, a decision he appealed and was denied. In both cases, the Veterans Board of Appeal considered the evidence, which in Bufkin's case conflicted, and in Thornton's case did not support a higher disability rating. And look, these are the two things that we are always talking about to really hammer home. One, the proof that it's service-connected, and two, the proof of the level of impairment so you can be rated appropriately, right? Make it black and white, use the VA's rating schedule and all that stuff. Let's move on. When the cases went before the Veterans Court of Appeals, the court determined that no errors were made by either the adjudicators or the board. The court did not conduct a benefit of the doubt review, and the Federal Circuit Court of Appeals agreed it was not necessary. The plaintiffs appealed to the Supreme Court, arguing that the lower court was wrong, given that the law spells out that veterans deserve the benefit of the doubt. The Federal Circuit ignored the plain text of the statute and frustrated Congress's clear intent to provide for enhanced appellate review and enforcement of the benefit of the doubt rule. Attorneys wrote in their petition to the highest court. The VA argued that the claims were properly handled, with Bufkin failing to provide evidence that his condition was service-connected or that he even had PTSD, and Thornton, who received a benefit of the doubt decision that resulted in a 50% disability rating, did not meet the criteria for a 70% rating. VA attorneys said the Court of Appeals and the Federal Circuit both ruled appropriately, and the law only required the Veterans Court of Appeals to review the board decision for error, not to review benefit of the doubt determinations. Even if the question presented warranted this court's review, these cases would be poor vehicles in which to address it. Justice Department attorneys for VA Secretary Dennis McDonough wrote in a response. A ruling in favor of Bufkin and Thornton could force, this is the big part, a ruling in favor of Bufkin and Thornton could force changes in how the VA appeals court considers such cases, potentially changing the outcome of claims currently under consideration as well as past claims. Renee Burbank, Director of Litigation at the National Veterans Legal Services Program, one of the nonprofits that filed a brief to the court supporting the plaintiffs, said Tuesday a decision to overturn the ruling could put the Veterans Court in a stronger position to examine the evidence and make more decisions than it currently does. It also could help speed up the legal process regarding appeals, since currently Claims may languish in the courts, which we all know, for years as veterans file repeated appeals that never come under benefit of the doubt consideration, she said. A ruling in favor of the plaintiffs would not be a huge burden on the court, she said. It would require the court to get a sense of whether the board looked at all it if the board looked at all of it and made an analysis of whether evidence was in a rough approximate balance. And if so, tie goes to the veteran, Burbank says. Additional groups that filed briefs favoring the plaintiffs include Disabled American Veterans, the National Law School Veterans Clinic Consortium, Military Veterans Advocacy, and the Federal Circuit Bar Association. Arguments are scheduled for 10 a.m. Wednesday. So here we are pushing this out to you. I believe that it's this Wednesday right now. Here we are at 11 o'clock Eastern Time. I'm assuming that this is all Eastern Time since it is with the Supreme Court. So with that, thanks so much for watching. I appreciate you. Have a great one. And remember, if we don't take care of each other, something went wrong.